Well, thank you for being here in person or for taking the time to watch the presentation. I want to thank the City Center for hosting. The City Center is the University of Colorado Denver's front door to the community, where partnerships are formed, talent and knowledge are shared, and innovative solutions to urban challenges are advanced. We're here this evening to discuss how hiring international graduates can contribute to the success of your organization and to share information about the immigration options available to you. Hiring international graduates from the University of Colorado Denver is very much within your reach. I would like to introduce the wonderful panelists that we have with us tonight. All of them are local immigration attorneys. Lisa York has practiced immigration law for over 15 years. She recently joined the firm of Stern & Curray. One of her emphases is employment-based immigration, and she is focused on work visas for small companies as well as student visa issues, among many other areas. She is an AILA member, and she served on that organization's Board of Governors from 2014 to 2017. Brad Hendricks, immigration practice at Caplan and Earnest, focuses on immigration and employer compliance and planning. He deals with complex areas such as multinational manager petitions and visa options for physicians and entrepreneurs. He is the past chair of AILA Colorado. And Stephen Williams is an associate at Ogletree Deakins. He's worked within institutions of higher education, including right here at CU Denver, and he focuses on business immigration, representing organizations and individuals in academia, medicine, and high tech. We've divided our discussion into 6 distinct sections: why hire international graduates, optional practical training, STEM OPT extensions, H-1B basics, changes in the H-1B process, and then setting the stage for a successful employment-based permanent residency. So Stephen, can you tell us what employers need to know about hiring someone on OPT?
Sure. So in order for an employer to hire a student who has optional practical training, which can last for a year or up to 3 years, I think Lisa might talk a little bit more about the STEM extension, but for the initial 1-year period of OPT, it's relatively simple for an employer to onboard an F1 student. Basically, it's up to the student to be able to talk to the employer once they get an offer, a letter from you explaining some of the employment details. Then they provide that letter to their university, and the university authorizes them to be able to engage in that employment by issuing an I-20. They do have to submit an application to the U.S. Citizenship and Immigration Services. It's called an I-765 Employment Authorization Document Application, and that can take some time for that to come back. But as they do that and they submit that application, they have that offer from you. Once they get that document, they simply appear and show up for the first day of employment, show you that document authorizing them to work for you, and then they're good to go.
Lisa, can you explain who's eligible for a STEM OPT extension and what international graduates, employers, and the school needs to do to obtain that extension?
All right, so a STEM OPT extension is an extension of the optional practical training period that is available to students who are in the sciences, technology, engineering, or mathematics fields. And the whole idea behind this STEM OPT extension is that because it's so difficult for people to win the H-1B lottery, and we'll be talking about H-1B visas in just a moment, to move on in their careers and be able to stay here in the United States, these provisions were enacted to enable students to extend their work authorization with their employers for an additional 2 years. There are some reporting requirements and some additional criteria that need to be met in order to be eligible for STEM OPT. One of the biggest ones is that employers who are applying for a STEM OPT extension for one of their employees must enroll in E-Verify, which is USCIS's online I-9 system. In addition, there are certain reporting requirements, including the fact that students and their employers need to come up with a training plan. that kind of addresses how they're going to be learning certain things and objectives towards their degree and their major during that STEM OPT extension. Employers and students are also required to report things such as address changes, as well as terminations or changes of employment through their DSO.
For all of you, what are some of the issues with OPTs or STEM OPT extensions that employers need to know about and maybe that you've seen come up?
I mean, I can jump in and I think
Yes.
timing is one of the bigger issues. Typically when somebody is transitioning from that 1 year of initial OPT into a STEM OPT, they will need to obtain another employment authorization document. Stephen mentioned the need to obtain one of those. And for some folks, the challenge can be, how do I go about actually getting that document on time? A lot of employers are not aware that students typically do, by making a timely filing for an extension, they are able to continue to work, but it is for a period of 180 days. So sometimes timing can become an issue with those.
Okay. Anything else, Lisa or Stephen?
And to add on to that a little bit, the primary timing issue is the initial application. So we've seen delays in the adjudication of the I-765 employment authorization documents, and the student can't begin working until that employment authorization document comes through. And there's a limited time window where they're able to submit that application, and sometimes they're taking longer than that time window allows and when the employer would like them to start. So there are some issues there. The other primary issue that we've seen, and this is less of the employer's issue, but it's something to be aware of, is what we call maintenance of status. So students are only allowed to have a certain number of days of unemployment in OPT and STEM OPT. And so if a student is transitioning to you and has either not been employed or has been employed with a different employer on OPT, sometimes there can be issues with how long there may have been a gap in employment. Again, not something that an employer has to be an expert on, but something to be aware of, that there are some limitations there.
Great.
And I think that's particularly important
Right.
in light of the new guidance that has recently come out in terms of the accrual of unlawful presence for status violations for students.
Yeah.
So that is very important. I would just add that I think sometimes employers who are not already enrolled in E-Verify are a little hesitant to enroll in E-Verify, and there are both pluses and minuses to enrolling in that system. So, from a corporate company perspective, that is definitely a discussion that you want to have with your immigration attorney to see whether or not that is the right fit for you, and what the potential pitfalls of enrolling in E-Verify might be.
Well, let's move on to talk about H-1Bs now. Brad, what are some of the things that employers need to be aware of if they want to file an H-1B for an international employee? Maybe a CU Denver graduate who's currently on OPT.
For example, yes. So there are really a couple of main things that employers need to think about with this. And I think about this in the sense of eligibility, timing, and then what it really means to employ an H-1B worker. So in terms of eligibility, an H-1B visa is for professionals who are working in a specialty occupation. Professional is generally defined as somebody who has at least a 4-year bachelor's degree. And a specialty occupation is an occupation that is generally something where you need a specific type of a degree for entry into the field. When I talk to people about this, I oftentimes use myself as an example, because when I was a lawyer, or when I was graduating from law school and going to work as a lawyer, that's a pretty good specialty occupation H-1B, because I have a field of study that really matches what I was going to do. As opposed to my undergraduate, when I was in some sort of pre-law sociology, political science type of a role, and then moved into working for a clothing company, doing manufacturing and importing. Totally unrelated, terrible H-1B. So I had the degree, but I certainly didn't have something that matched. So employers what they're going to want to do is try to assess, do we have a degree that matches? Do we have what we would consider to be a specialty occupation? We're really looking for a limited field or limited set of fields of study to get into this. From a timing perspective, timing is important. There are only a limited number of H-1B visas available each year. That number is 85,000, but of that 85,000, 20,000 are reserved for people who have advanced degrees from U.S. Colleges and universities, which is a master's or above. And they are issued by the fiscal year, which is October 1st, and the way that the immigration rules work is you can apply 6 months in advance of need. So what that means is that on April 1st, you can start making an application for an H-1B job that's going to start on October 1st. Because there are only a limited number of H-1B visas available, what typically happens is that there are more applications than there are spots, and we end up having to run a lottery for the H-1Bs. And so they take all of the applications that go in, they randomly select the applications that will be accepted for processing, and then they move those applications through and judge them on the merits. The ones that are not selected, the applications are actually returned right to the employer. But one of the frustrating parts for employers is that typically you do have to get the whole application ready, get everything filed before you even know if your case is going to be accepted for processing. And then I'll mention that employers often ask me how difficult it is to employ an H-1B worker. And like Stephen mentioned with the idea of onboarding a person who's an F1 OPT as an employee, employing an H-1B worker is not terribly different than employing any other worker. Typically the H-1B rules do require that you pay the individual the minimum prevailing wage for the position, but they want people to be treated in the same way as all the other employees are in terms of benefits and other terms and conditions of employment. Work location is very important with H-1Bs, and there are some obligations in terms of holding on to some paperwork, what's known as a public access file. And I think that the biggest difference that most of my employers see is that if you terminate that H-1B worker before the end of their time in H-1B, you are obligated to pay for a coach class airline ticket for the worker back to his or her home country. So those tend to be the biggest issues around it. But for most, I think in my career I've had, I don't know, one or two over the last 15, 16 years.
I've never had one.
Yeah.
And that's because these folks are highly employable. None of them are headed back home. They're all going to be moving to a different position within another company.
Absolutely.
I actually have, as an employer, I have had to buy a coach class ticket for someone who needed to return home. But that was kind of extenuating circumstances. So I guess it does happen, but not very often.
That's right.
Brad, thank you so much for outlining what is a fairly complex situation. And now I'm going to ask all of you to chime in and just talk about some of the challenges that we've seen with H-1Bs recently.
What's happening is the Immigration Service is issuing what we call requests for evidence on most, if not all, of these cases, asking for employers and attorneys to provide additional information about why this position actually qualifies as a specialty occupation for H-1B visa status. Luckily, the word on the street is that the majority of those requests for evidence, the responses are successful, and the majority of those petitions are still being approved. However, the denial rates have gone up significantly in the last few years.
Yes.
Yeah. And Lisa mentioned, I'm not sure what's changed. I can tell you one thing that hasn't changed is the actual black letter law that applies to these cases. And this is part of the thing that has become a little bit frustrating for people in terms of how we prepare these applications. As Lisa mentioned, I think a few years ago, winning the lottery was the hard part. And now that's just the first of a couple of hurdles often that come up when you're trying to go through the processing. So it is important to make your evaluations, try to be realistic in terms of who your candidates are as you're going through the process.
And go ahead,
If I may,
Stephen.
just one more thing that is impacting what this looks like on the ground. Over the last couple of years, the government has started to suspend what's called premium processing. This is a service where you can pay an additional fee and have your case processed within 15 calendar days for an initial response. And it really is a great benefit to many employers to get clarity, particularly when you're transferring an employee from one company who already has an H-1B onto your company, or for H-1B lottery cases. We've seen issues this year where cases that receive requests for evidence or even initial action on a case, they're pending well beyond October 1st. And so they're not able to get into that H-1B status on the normal date of October 1st because of this suspension of premium processing. And that's something that is completely in the discretion of the government, and they've gone back and forth as far as when it's available and when it's not, but it is something that makes it, practically speaking, more difficult to successfully transition an employee into H-1B status.
Thank you. And I would just add that one of the challenges and that we're seeing really across the board with I-765s in the OPT context, with H-1B processing times and even into permanent residency, is just slower and slower processing times. It makes it really important, as everyone here has stressed, to be well aware of the timing issues and to get good advice from the get-go so that you don't face some of these issues.
Michelle, if I could say one other
Yes,
thing
please.
as well,
Yes.
which is that when you talk to immigration lawyers about this, oftentimes we'll probably talk about the good old days and, oh, it was so much easier back then and everything like that. But I do try to encourage the employers that I work with not to let that dissuade you from going through this process. I mean, I can speak for everybody up here. We'll be realistic. A good immigration lawyer will be realistic with you about what your chances are for something like this. Because we do have some information and we are seeing what's happening on the ground. So although we may hear the heavy sighs and we may sound doom and gloom up there, it's not. We don't want to put that as the type of reason why you should just walk away from this process altogether, because you do end up with some outstanding dynamic candidates who come in to your workplace, which is fantastic.
Yeah,
Well
and again,
said.
90% approval rate.
Yeah, still by
Still.
far the majority
Yeah.
are approved.
Oh, yeah, definitely.
Yeah, and it's just a little more challenging than the easy approvals that we've seen in the past. But that doesn't mean that with the help of a great immigration attorney like any of the folks here, that you can't get that H-1B approved. Okay, Stephen, let's talk now about the final rule for more effective and efficient H-1B visa program. What's going to change for the 2020 H-1B filing season?
So this is late breaking news. The final rule went into effect, I believe, yesterday,
Yep.
right?
Yes.
And so this is brand new. There's good news and bad news. But to back up a little bit, what this rule means, there's two primary parts to this rule. One is, as Brad mentioned, the lottery system is broken into two different pieces. There's the 65,000 for those with at least a at least a bachelor's degree. Doesn't have to be a U.S. bachelor's degree. And then the second group of 20,000 that have a U.S. advanced degree, master's, PhD, et cetera. So the first piece that will go into effect this year, for this year's cap season, is that they are reversing the way that the lotteries are run. Traditionally, they've run the 20,000 first. So those with U.S. master's degrees or above are run first. And then if they're not selected, they're lumped in with the 65,000 for a second lottery. What they've done is they've reversed the order of these lotteries. So everyone will be run for those 65,000 slots. And then those that weren't selected, that do have U.S. master's degrees, will be run through the lottery for the 20,000. Sounds very confusing. What it means on the ground is that there's a substantial additional number of those with U.S. master's degrees that will be selected in the lottery. Increases your chances by, the government estimates about 16%. So whereas before maybe you had a 40% chance, that may be up above 50% if the numbers remain consistent from year to year as they have for the last couple of years. So that's the first piece of this new rule, and will go into effect for this year. They confirmed. The second piece is a registration system.
And
Maybe
and
Lisa
we're
will
gonna-
talk more about
well,
that.
I will ask Lisa to talk about that. This really confusing kind of part that I certainly would like edification on.
Yeah. So the second part of this rule change is that the Immigration Service wants to institute a system whereby employers are registering electronically in advance of the H-1B visa lottery to basically figure out whether or not they can go forward and apply for it. Basically, through this registration system, they're trying to eliminate this lottery, which I don't think is necessarily a bad thing. But I think most people are not unhappy about this. I think that there are a lot of logistical and IT issues that we're very concerned about. So the way that this would work is that the Immigration Service is going to set up an electronic, web-based registration system. And so upon notice, and at least, I believe it's at least 30, they'll give notice 30 days before the 14-day period opens up, where all the employers in the United States will go on and register. My understanding, and it's not clear yet, I think in the final rule exactly what information they're going to be asking for, but it's simple biographical information: the employer's name, the beneficiary's name, the position title, address, stuff like that. Nothing substantive as far as we know at this point in time. And then everybody's going to get kind of like, they're going to run the lottery in advance, and then the employers will be notified whether or not they can move forward and file an H-1B visa petition. And then after that registration period is over and all the employers who can move forward have been notified, the Immigration Service will then designate a period of time, and they're going to give 90 days for all of the people who have been given the green light to go ahead and file the H-1B visa petition. So the whole idea, I think, is to eliminate uncertainty, to take away this random lottery process, and give employers and employees, advance notice about whether or not they can move forward with that petition in any given fiscal year. As part of the final rule, I think the Immigration Service also has acknowledged the IT challenges. They have written into the rule the ability to suspend it. So if they don't feel they're up to snuff and they're not ready to go forward, they can suspend it. I think once they get this thing working, it's going to be better for everyone who is trying to apply for an H-1B visa.
And one of the concerns that we were thinking about was just that the barrier to entry with respect to the registration, especially if the information that you need to provide is so minimal. I wonder if that will really eliminate some of the chaos that's currently happening with respect to the lottery. If it's found that, well, we've allowed 85,000 or however it is they do it, all of these folks to apply, and then come to find out that, oh, well, we really actually aren't going to file an H-1B. We didn't really understand what the challenges were or the costs were, perhaps. I wonder too about that. Anybody want to comment?
So just to give some perspective here, there's been about 200,000 or so applicants over the last several years, and there are significant barriers to entry at this point, the old system, right? Because an entire H-1B petition had to be prepared in advance and filed on April 1st or the week following April 1st. And then if the application wasn't selected, the government would send back the hard copy application and send it back, which involves all the legal fees that are involved there if you have an attorney involved. The filing fees are returned, so there's not as much of a barrier to entry there, but it's a lot more work. And so to your point, Michelle, we could see a great increase in the number of people that are willing to register, but then once they realize more what the process is like, they won't pursue it, and presumably those lottery numbers will then be lost. So that is a viable concern and a real issue.
They are supposed to recapture those numbers. So any unused numbers in any fiscal given year are supposed to be recaptured. They're supposed to grab them and then add them back to the next fiscal year. But the question is, are they going to be able to do it, and how will they do it?
Right. And I think it does beg the question too about it could make it significantly harder in terms of the number of people that are throwing an application in there, whether they're qualified or not. One of the first things we talked about was the idea of being qualified for the H-1B, and so we could have a huge number of unqualified folks throwing their names in. The other issue I think that comes up as well is one of the first questions that always comes up under the current system about the lottery is, all right, I'll just throw in 4 or 5 applications and everything will be good. I'll increase my chances. Well, part of the reason it takes them so long to run the lottery right now is because they do have to go through and identify, do we have duplicate applications for the same employer, for the same employee? And right now, when you have, when you have a system where there is a pretty hefty barrier to entry, you don't see that too frequently because people do have to put a lot of work into an application. My concern is if you get to a situation or a system where it's so easy to enter and you've got 2 people in HR who may not be talking to each other, or worse, an employer and an employee who both think that they've done the registration and then it turns out that they haven't. They may be accidentally eliminating themselves from consideration, and that's always a point of frustration. And they acknowledge this in the rule itself when they wrote it, that they did not know exactly how to deal with this particular problem in this particular situation that came up. And in fact, when they put the initial rule out for review, they said, we're anxious to hear anybody's suggestions on how we might deal with this particular issue.
I think there will be litigation on that issue, and so we'll just have to stay tuned and see how this all plays out. At least for this year, it's whether you like it or not, it's business as usual, and we know that except for the reversal of that, unless there's litigation staying that hopefully it will be a quote-unquote normal cap year.
Well, we'll hope for that.
If such a thing exists.
Yeah. I want to go back just for employers who perhaps have an OPT, someone who's working on OPT or STEM OPT, and maybe they still have some time left. Should they be thinking about filing this year?
In my opinion, yes. I mean, typically if you have that OPT, or even if you have OPT and you're going to qualify for the STEM, I typically encourage people to go ahead and put yourself into the lottery.
I think the only exception to that, and we didn't really talk about this, and this is a limited subset of employers, but there are some employers that aren't subject to the lottery, including universities, nonprofit research entities, and governmental research entities. So those employers aren't subject to this lottery system. They can apply for an H-1B for their employees at any point. And so oftentimes, because there's a limit in the amount of H-1B time that you have, there's 6 years maximum, there can be an advantage to using as much of your OPT time as possible. But that's, again, a relatively limited subset of employers and a kind of a unique circumstance. But definitely agreed that you want to, if you're subject to that lottery, you want to apply early and often.
Good point. Okay.
Well, and the other thing is that this is where having a good immigration attorney is very important, because the other discussion you should be having with your attorney is, are there any other options, visa options that are available, or is there a way that we can jump right into the permanent residence process and bypass the H-1B process at all? So that is a very important and valid discussion that you need to be having with your attorney before you decide kind of on your strategy in terms of going forward with an H-1B visa petition.
As the last question here, I would just, like all of you to comment, what's the most important thing that employers can do to ensure that employment-based permanent residency continues to be a viable option for somebody that you want to retain for the long term?
Well, I think it's sort of that classic begin with the end in mind in terms of thinking about what you want to have done. And if permanent residence is the goal, that's certainly something that can be accomplished. What we've talked a lot about tonight is moving into an H-1B, which is also a non-immigrant and temporary visa. Stephen mentioned the notion of that most H-1Bs, or just about all H-1Bs out there, are limited to 6 years. And so in order to make sure that you don't run out of time, or that there are some limited categories where you can extend beyond 6 years, you do want to plan in advance. And so having a good understanding of where you're trying to go at the outset is good. And it's a great conversation to have. Typically when I meet up with a client, a foreign national, an employer, one of the first questions I ask, I try not to take it for granted, what's your goal? What do you want to accomplish out of this process? Do you just want to be here and get 2 years of experience, or are you looking to make a life and a career here? And that's really going to help drive some of the strategy components that we come up with for each person.
As some of you or most of you may or may not know, The current U.S. immigration system is under huge scrutiny, and I think it's very critical. American business needs to speak out. These folks who are here graduating from our universities with these STEM degrees are critical to our labor force. Our economy is going rockets right now, and a lot of that is because of the people that we are able to employ who, for whatever reason don't come from this country or weren't born here and need to be sponsored for that. So it's very important, I think, for American business to speak out. It's time to start talking about how it's essential that we have these processes in place, and that it is a critical part of the American economy.
The permanent residency process has great long-term benefits, and it takes a long time to get there. For some individuals from certain countries, it can take many, many years, but you need to take certain steps in the meantime to ensure that they can continue to maintain their non-immigrant status. So really having the discussion early and often, not being afraid to broach that subject, and getting informed. It's really key to understand at least the basics of what's involved in this process, what is required from you as an employer. Overall, the most common type of green card requires that you go through a process with the Department of Labor to show that this individual is the only qualified, willing, or able U.S. or permanent resident worker, which sounds really intimidating when you hear it just like that, but it's very possible. It's done all the time. It matters a lot what your minimum qualifications are and various things that you do in that regard. But again, the key is to think ahead and to become informed early on.
Wonderful. Well, I'd like to say a huge thank you to our excellent panelists. You shared a lot of very valuable information, and it was really my pleasure having you.
Thanks very much.
Thanks, Michelle.
And now that you know more about optional practical training, H-1Bs, and beyond, you can do what other Denver area employers like Wells Fargo, KPMG, EchoStar, and the Colorado Department of Transportation have done, and confidently hire international graduates who will undoubtedly contribute to your organization's success. Thank you very much.